I am Catherine Macon, Vice Chair of Beverly Hill Bar Association's Ethics and Malpractice Law Section. I am delighted to introduce our speakers today, Joel Osman and Jeff Kitchaven. Joel Osman is partner and general counsel at Parker Shafi LLP, where he concentrates his practice on complex litigation and trials. He brings decades of experience across professional liability, general liability, product liability, construction defect, and commercial litigation, with a particular focus on the defense of lawyers and legal ethics. Joel has tried numerous jury trials to verdict and is widely respected for his leadership and professional responsibility matters. Jeff Kitchaven is one of America's leading mediators. He is ranked in Chambers Band 1 on the national list of mediators, and Who's Who Legal has honored him as a global elite thought leader in mediation. A full-time professional mediator since 1996, Jeff is a cum laude graduate at Harvard Law School and a Phi Beta Kappa graduate of the University of California, Berkeley. He specializes in B2B cases, particularly insurance coverage, intellectual property, and legal and accounting malpractice. He is a past president of the Southern California Mediation Association and a past chair of the ADR section of the LA County Bar, as well as an elected member of the American Law Institute. Jeff has taught mediation for Harvard Law School, Pepperdine University, School of Law, the American Bar Association, and many other law school and bar associations across the country. His views on mediation have been cited in the New York Times and the Wall Street Journal. And with that, let's get started.
Okay, good afternoon, everybody, and welcome. On behalf of myself and Jeff, we'd like to thank the Beverly Hills Bar Association for this opportunity to present. This is one of several similar speeches that we've given to a number of organizations in the last few months. My colleague Jeff has written extensively on the subject since ABA Formal Opinion 518 was first introduced in the fall of 2025. And our goal here today is to provide essentially a conversation rather than a speech in which we discuss the various topics that are presented in the slides. The slides will be available for the audience if you wish to obtain them. And with that, let's move to the next slide, please. So, Jeff, our initial inquiry is, what is Formal Opinion 518?
Joel, thank you. It's a pleasure to be here with you again. Thanks to Catherine for that very generous introduction. And let me just say, by way of preference, it's always a special treat for me to be participating in the advancement of the mission of the Beverly Hills Bar Association. It's always a bit of a homecoming for me. I'm a graduate of Beverly Hills High School and grew up in Beverly Hills. And so it's nice to come home and be welcomed so warmly by the good folks at the Beverly Hills Bar Association. So this is a formal ethics opinion of the American Bar Association, number 518, issued last October, and it applies to it describes the ethical duties of lawyers serving as mediators. And the more I speak on this subject and write on it, the more I discuss it with people, the more clear it seems to me that this opinion really talks about mediator ethics in the context of legal ethics, in that mediators have certain ethical values, certain ethical principles by which we stand, most notably neutrality and self-determination. Lawyers have their ethical duties. They have the duty of competence under Model Rule 1.1. They have the duty of using independent judgment in Rule 2.1. There are rules against non-delegation of lawyering responsibilities. And what Opinion 518 does, when you pull back and look at the big picture, is it shows how the ethical duties of lawyers and the ethical duties of mediators fit together. Because let's face it, for mediators, the goodwill of lawyers is critical to our very existence as mediators. And we have to create an environment that's hospitable for lawyers. Hospitable, among other ways, in the sense of creating a place where they can fully discharge their ethical obligations to their clients without mediators crossing over into the lawyer's lane. And what 518 does is it keeps mediators in their lane as mediators so that lawyers can fully occupy their lane as lawyers and fully discharge their ethical obligations to their clients. It's also, Joel, critically important to non-lawyers serving as mediators because 518 makes clear that mediators should not do things that, as I said, cross the lane into lawyering responsibilities and the practice of law. And that's important to the non-lawyers serving as mediators, because if mediation necessarily involved the performance of duties that were lawyering duties, then only lawyers could be mediators, because you would need a law license to perform some of the functions of mediator as well as the responsibilities of lawyers. Now, the field of mediation is very much enriched by having people not only from the legal profession, but from other fields as well. And in order to keep the field of mediation dynamic and growing, to allow people from all different backgrounds to flourish in our field, 518 does everyone a favor by making clear that the practice of mediation is one thing, the practice of law is something else, and we should not get them mixed up.
Jeff, I couldn't agree with you more about that. At the risk of sounding like we're talking war stories here, you might recall some decades back when we first developed the world of private neutrals, it was assumed that all the private neutrals were basically going to be former judges. And it was not, too many decades ago when we first started to see non-judges, as in mostly lawyers, taking up the role of being a private neutral. And subsequently, we now have a situation where we have people who are non-lawyers serving in that role as well. But the key, and the risk, and I don't mean to be repeating you, Jeff, but the key distinction in 518 is, even though the language of 518 speaks mostly in terms of what the role of a mediator is, it's clear from the context of that opinion that 518 really talks about the role of the mediator and the role of the attorney and how those roles differ. Mostly they differ in the exercise of independent judgment and the exercise of advocacy on behalf of the lawyer's clients, as opposed to the role of the mediator, which is generally not as an advocate.
Yes, and Joel, shall I go over the highlights of what 518 provides?
Let's move to the next slide, please, where we focus on the key holdings of 518.
Thanks, Joel. So first of all, let me say what I'm not going to talk about. There's a lot of 518 that talks about mediators and pro se litigants. Frankly, it's not the world in which I operate in commercial litigation. Everybody comes with lawyers who are appropriate to the task and do a terrific job, by and large, of representing their clients. It's a rare case where they don't. So for those of us operating in the world where clients come represented by lawyers, there are three things in 518 that really stick out to me. Number one, mediators are not supposed to exaggerate their statement of the evaluation of the strengths or weaknesses of someone's case. This is terrific. This really cleans up a lot of bad stuff in the field of mediation. And that is the untrained or undertrained mediators thinking that what mediation is you go into conference room East and you wag your finger at the plaintiff and say, your case is terrible, you're never going to recover a dime, you'll be lucky to get out of here with one plugged nickel for a release, and just trying to bully and scare people. And then the mediator goes down to the conference room at the other end of the hall and wags that same finger at the defendant and says, your case stinks, you're going to be taken to the cleaners, open your checkbook, hollow out your pockets, let's get the gold fillings out of your teeth. This is the time you got to pay. And It's just bad mediation practice, yet it's common, still common from what I hear, what I understand. And this cleans up that, I believe, inappropriate conduct by mediators. Evaluation, great, as long as you're honest about it. The second thing that 518 does, it says mediators should not falsely state that something is a party's top dollar or bottom line. That is, they'll never pay more than X, they'll never take less than Y, if the mediator believes that it's not true. Now, in fact, I think good practice for mediators goes farther than that. And even if you happen to believe that something is a party's top dollar or bottom line, mediator should not state it as an unequivocal fact. Because in truth, somebody may be spinning us, somebody may be bluffing us, somebody may be manipulating us to go and deliver a message that simply is not the true top dollar or bottom line. As mediators, we should not fall for that. So it's okay to say, they tell me that this is their top dollar, they tell me that this is their bottom line, but remember that the mediator is really a merchant in hearsay when the mediator comes down the hall and says that. The mediator is in essence repeating what the folks at the other end of the hall have said. And we all know the reason why hearsay is generally inadmissible is because it's unreliable. And so lawyers ought not to be advising their clients based on the hearsay statements of a mediator. They ought to be doing their own hard work, exercising their own independent judgment to determine for themselves whether something is truly a top dollar or bottom line. And the third and final thing that Opinion 518 makes clear is that mediators should not state that something is in a party's best interest. So, for example, a lawyer can say to their own client, I think this is in your best interest. A mediator can evaluate and say, I think your case has only a remote chance of winning. I think you have only a remote chance of obtaining damages in a certain range or not. That kind of evaluation is fine. But then to go the extra step and say, so therefore I, mediator, am telling you, the lawyer's client, that it's in your best interest to accept a settlement on thus and so terms, inappropriate. Because as mediators, we don't really know the underlying clients. We probably met them just that day. We don't know their psychology. We don't know their true financial situation. We don't know their psychological profile in terms of aversion or tolerance of risk. We don't know how badly they may or may not need money for other purposes in their life. So for us to tell people that something is or is not in their best interest, for we as mediators to say it, is really presumptuous. And underlying all of this, Joel, is the ethical prohibition under which all lawyers operate. We're not supposed to lie, right? Lying, particularly to your own client, is extreme moral turpitude, and it'll get you a call from the state bar, and nobody wants that. Now, there is an exception to the lying prohibition for lawyers in certain negotiation contexts. Bluffing, puffery, things of that nature. There's a long history and tradition of lawyers bluffing and puffing in negotiations. And the reason that that's okay is because when you're looking in the eye of your adversary, your guard is up, your defenses are up, and you know that your adversary may be deceiving you. So trust but verify. You have to be on guard when your adversary is talking to you. But that exception to the prohibition against lying does not apply to mediators, and it should not apply to mediators, and 518 makes clear that it does not apply to mediators. Because remember, when a mediator is talking to you, a lawyer, in the context of a mediation, that mediator is in part working for you. You have, you're paying part of the fee, chances are, You're telling the mediator things that you expect to be held in confidence. You have some kind of relationship with the mediator. There are certain obligations of loyalty and competence that are owing from the mediator to each of the participants in the mediation. And so when a mediator is talking to you, you don't necessarily put up your guard or put up your defenses. Indeed, you just don't, because after all, the mediator is working for you as much as the mediator is working for the other side. And you have a right to expect honest, straightforward dealing from this mediator in whom you've placed confidence.
So, Jeff, to recap, if I'm acting in my role as an attorney and advocate for my client, a certain amount of huffing, puffing, and bluffing is okay, but it still remains my job to express to my client what's in my client's best interests. It's not the job of the mediator to do so. And this is, I think, a critical distinction, and one that's implied, if not expressly stated, in 518. But it is, I think, one of the key focuses of the opinions that you and I want to express this afternoon.
I agree, Joel. To put it in a larger context, remember your client, the underlying parties to the lawsuit, they do have a constitutional right to a jury trial. And it's not the role of the mediator to bully or badger people into sacrificing their right to a jury trial. When they come to a mediation, they're coming for the process to enable them to make better decisions. I often characterize it this way, that the true goal of the mediation is to help people make clear, strong decisions in a calm, informed environment. And settlements are the natural byproduct of that process. Indeed, the application of force or bullying in mediation, in my experience, generally creates nothing more than resistance. And instead, what we want to do as mediators is help people understand reasons why they might decide on their own to consider settlement options they had not considered before, or to consider more seriously settlement options they had not considered seriously before. That's what I think good mediation is.
And with that, let's move to the next slide and talk a little bit about the specific holdings in 518. And by the way, for our audience purposes, we've not provided you with the entire text of 518 in this PowerPoint presentation. I recommend the full text of that opinion to everybody's attention. It's worth reading. It's worth considering. But we have a few snippets of quotes from 518, which I think are telling. The first one is the following quote, which says that a lawyer mediator should avoid communicating in a manner that might be taken as rendering legal advice or otherwise suggesting to a mediation party that the lawyer mediator's role is to protect or advance a party's legal interest or to help the party obtain a particular desired result. It's not misleading, however, to provide legal information or to discuss the parties' respective views of how a tribunal might resolve a legal or factual question. How do you feel about that quote, Jeff?
I think that's sound advice, Joel. To provide information that's helpful to people in making decisions, I think if a mediator knows something that will help someone make a decision, unless it's been told to them in confidence by other parties to the mediation, if you know something that will help someone make a sound decision, I think you're almost obligated, one way or another, you're obligated to tell people things that will help them make good decisions under the circumstance. If you have analysis of facts or law and you believe that someone has only a remote chance of winning a case, well, it may very well help them to know that, take that into account in their analysis. They make the final decision. I sometimes use this analogy. Let's say you're listening to the 11 o'clock news on television and the weather report comes on. And the weather reporter says, there's a 40% chance of rain tomorrow. Okay, that's an evaluation, a prediction of what the weather's going to be. You make your own decision as to whether you're going to take an umbrella. Some people take an umbrella when it's a 40% chance of rain. Some people don't, for a whole variety of reasons. So the mediator can say, I think you may have only a less than 50-50 chance of winning this case. But again, some people like to bet against the odds. Some people have reasons extrinsic to the mediation or this particular case why they do or don't want to settle, why they might want to pay more or take less. Things that mediators have no way of knowing. You, as the lawyers, know a lot more about your client's circumstances than we do. And you're the ones who ought to be advising them as to what risks they really should consider taking or not taking. Now, Joel, we as
Jeff, I think
mediators,
that's exactly the converse, the flip side of this quote. It's not the mediator's role to do this, but it is the lawyer's role, my role as an advocate, to render legal advice to my clients and to protect or advance their particular interests. 518 tells us it's not the mediator's role. Therefore, by process of elimination, it's my role as an advocate in a mediation process. And again, that seems to me to be the clear takeaway from certainly this portion of 518 and generally from 518 in general.
that's right, Joel. And let me add to that. The mediator is not just a potted plant sitting there. Many times, lawyers come to mediation with their clients to solicit the mediator's help in breaking bad news to their own client. I imagine if I ask the viewers of this webinar, I'm sure they'll tell me that this has never happened to any of them, but perhaps they've had a friend, a neighbor, former law partner, a friend, who's had the experience of a client with unrealistic expectations. Joel, you ever had a friend who's had that problem?
Not more than 3 or 4 times this week.
Oh, there you have it. So that's one of the great services that mediators can provide, which is assisting lawyers in breaking that bad news and helping get unrealistic expectations back down to planet Earth. Always in the client's best interest. Always in the client's best interest. And so what we may do, Joel, there have been many times I've been in a caucus with a lawyer and his or her client where sometimes a lawyer asks me to take the lead. And I'll say, look, here's how I see the case. You're going to have problems getting this evidence introduced. I don't think the judge is going to go for this measure of damages. You're not likely to get this jury instruction. I don't think this motion in limine is going to go your way. There's some real challenges here. And I think you should be making your decisions in light of this 360-degree view of what the circumstances are. After I, as mediator, and other mediators give that spiel, there's usually a dead silence in the room. And at that point, it's appropriate for the mediator to say, would you like me to step out for a moment while you can discuss that among yourselves? And that's where the advice comes from the lawyer as to what is in the client's best interest. Sometimes the lawyer wants to take the lead in that caucus conversation, mediator, lawyer, client, and you, Joel, or whoever's the lawyer in that circumstance, will talk about the risks, what you've learned during the course of the mediation, where you see the case coming out, and as mediator, assuming that it's true, for the mediator to say so, we say, yeah, your lawyer has studied this case very carefully, has analyzed things very thoroughly, and I think your lawyer's analysis is right. And this solves a big challenge that lawyers have, which is in the privacy of your office, Joel. I'm sure if you're anything like most other lawyers I've ever met, you have conversations with your lawyer in the privacy of your office. You try to explain the challenges of the case. Case maybe isn't panning out the way you thought it would when the litigation started. Big problems, big risks. And the client turns to you and says, well, yeah, Joel, I know that, man. That's why I hired you. You're a great lawyer. You're going to win this case anyway. And that can be a showstopper for many lawyers in the privacy of the office. But when you're in the public more public context of a mediation, where there's a stranger in the room, the mediator is sitting there, it's a lot harder for a client to be dismissive of that advice. In the presence of a stranger, it just improves everyone's openness and willingness to getting, as I say, that 360-degree view of the situation.
I think that's a good point. And with that, I'd like to turn to our next slide and our next quote from 518. If a party, particularly an unrepresented party, requests that the mediator provide legal advice, the mediator should again explain the mediator's role and advise the party to seek legal advice from counsel of their choice. Now, presumably, counsel of their choice would be the attorney who's representing the mediating party in that mediation, but I suppose it could be other people as well. Again, it seems to me that the gravamen of this particular quote from 518 is mediators don't give legal advice. Counsel give legal advice to their clients. Do you see anything beyond that that we should be taking in this comment?
Well, I think the big challenge is, I know the Beverly Hills Bar has a very robust family law section. I think that a lot of divorcing parties come to mediation because they cannot afford lawyers. I think that this poses some challenges. I don't mediate in the family law domain, and so I don't really know how to meet the challenge where you have unrepresented parties in a divorce case. Similarly, there may be community mediations, small claims mediations, other situations where people don't have lawyers for financial reasons or other reasons. And what I think 518 is saying is just because people don't come with lawyers doesn't mean that you, the mediator, should undertake the lawyering role. It's just not appropriate for mediators to do. Lawyers are supposed to have, people giving legal advice are supposed to have duties of undivided loyalty. Lawyers have duties of undivided loyalty. But if you're in a situation where you're mediator for both spouses getting a divorce, well, your loyalties are divided. So the giving of legal advice in that context is, pursuant to 518, just inappropriate. And it's a thin line. It can be a thin line, Joel, between providing evaluative input and giving legal information and giving legal advice. And it's a real challenge. It's a real challenge in family law and elsewhere.
It's a very thin line, even outside the context of family law. But again, sometimes the lawyer's advocate needs the impartial mediator to say yes or no. Not that they're giving legal advice, not that they're saying this is how the case is going to come out, but part of the value of the mediation process to me as an advocate and to my clients is to know what that third party thinks. And it's a very, very fine, narrow line that's being drawn here in 518, but it is clearly being drawn. Let's move to the next quote, please. Oops, back up. There you go. I think this is our final direct quote from 518.
Yes, Joel, we've dealt with the substance of this, I think, already, in terms of not making false statements, the prohibition on lying, applying to mediators more stringently than it applies to attorneys as advocates.
I agree. I think at this point, our quotes are getting a tad redundant. Do you think there's anything else that we should be adding to this thought at this point, Jeff?
Oh, it'll come up as the conversation rolls along.
Then let's move on to our next slide, please. So why does all this stuff matter to mediators? Jeff, you're a mediator. What's your perspective?
So we want to have mediation as a space that's appealing to lawyers. And if we are crossing over into the lawyer's lane and depriving the lawyers of the opportunity to occupy that lane fully and discharge and fulfill their ethical obligations to their clients completely, then mediation will ultimately be less appealing, unappealing to lawyers. We want to show lawyers the respect that's necessary in order to have lawyers want to use this wonderful set of processes that we call mediation that help clients in so many ways, that it helps lawyers in so many ways. We want to help lawyers be good lawyers. We don't want to supplant them. Lawyers have their job, we mediators have ours.
We seem to be getting a consistent theme here on that subject. Let's move on to the next slide.
Well, Joel, I've been doing a lot of these webinars with you, and I'm getting a lot of invitations to do them because of the articles that I've written. I have people coming up to me at conferences, and as they've read the articles, it's all they want to talk about with me. And I learn from each one of those conversations. And every time we do one of these, it's distilled, I think, a little more clearly. And so I'm glad we're able to give the wonderful audience here at the Beverly Hills Bar what I think are some more sophisticated insights and the essence of what this is really, what it's really intended to accomplish.
And in keeping with those more sophisticated insights, let's now talk about the differences between the role of the mediator and the role of the advocate. Jeff obviously spends his time being a mediator. I spend the bulk of my time being an advocate. And there are key differences in those roles in the mediation process. Advocates advocate. It's my job to speak on behalf of my client, to advocate on behalf of my client, to persuade on behalf of my client. Jeff's role is somewhat different. Jeff's role is to actually assist the parties in reaching a resolution. And we, both as advocates and as mediators, risk role confusion between those two roles at our peril. It's a problem for people.
Absolutely. Absolutely. It's the responsibility of everyone. My sense is that the people on the American Bar Association Ethics Committee are busy people. They're not interested in creating busy work or make work for themselves. And whoever were the principal drafters of Opinion 518 put in a lot of work on it. It's very thoughtful and it's very detailed. And I don't think they would have undertaken the task unless there was a perception of a problem. And as I wrote in one of the Daily Journal articles last year, we don't have any licensing for mediators. The California legislature is making some movement in that direction. I hope that they do not end up licensing of mediators. I think it would stifle innovation in the field and not contribute to quality control in any meaningful way. The consumers of mediation services, at least in the commercial arena, are sophisticated lawyers such as yourself, Joel, and I don't think you need licensing of mediators to pick a good mediator. You're able to do that due diligence on your own, just as you're able to pick a good restaurant on your own, or a good movie on your own, or a good book or good newspaper on your own, without having a licensure in place with respect to any of those fields or many other fields in our society. So we're not licensed, but you guys can. It's the marketplace that really monitors the quality of mediation, and I think that it does a darn good job of that. Still, there are entrants into the field, and we see it. We just look at the number of mediators that we have and how many new people are entering in the field. I think you can see the number of judges retiring from the Superior Court. I think you can look at the number of lawyers who fit mandatory retirement ages in their law firms, and everybody wants to be a mediator. Well, great. They should be able to try it. Some are going to succeed, some are not going to succeed. And in order to make sure, and I think that 518 arises out of a perception that mediators have to be policed by bar associations, by the marketplace, and other ways so that we can avoid licensure by governmental entities and provide quality services to the lawyers and your clients, Joel, whom we serve.
I agree. I think licensure of mediators is just a fundamentally bad idea. But I do think that mediators and the people who work in that field are very driven by the market. And those of us who practice in the, and deal with mediators all the time, there are a lot of people holding themselves out as private neutrals, an ever growing number of those people. But if you look carefully and you have anything to do with this world on a regular basis, you'll notice that there are some people who are really in demand and are really hard to get a hold of and really hard to schedule. And there's a lot of people who are simply not in demand. It's the marketplace at work. Speaking of the marketplace, Jeff made mention of his Daily Journal article. I recommend it to the audience's attention. This is an article, I believe this is the one, Jeff, that was published back on December 3rd of 2025 in the LA and San Francisco versions of the Daily Journal.
Joel, there's a couple of questions in the chat. Why don't we just take a moment out of our stream of consciousness here to address them? Brian Walters asks, let me summarize, when he chooses a mediator, he considers subject matter expertise and wants the mediator's evaluation of the relative strength or weakness. Are we saying that mediators cannot do that now? Not at all. Mediators, as I think we've emphasized, are free to evaluate, to share assessments of strengths and weaknesses. It's just that extra step of saying, and therefore it would be in your best interest to settle on the following terms. It's that last step that 518 prohibits. Erica Bristol asks, in California, how will these issues come to light or be discoverable with the significant mediation confidentiality obligations in place? Well, we do have our so-called absolute confidentiality statute, Evidence Code 1115 et sec. It's not really absolute, but we use that euphemism to describe it. And it's a serious issue. It was the issue raised in Cassell versus Superior Court. Justice Chin's brilliant concurring opinion in that case, that what we've basically done, I think, unfortunately, is we've basically suspended the rule of law when it comes to people's conduct in mediation. I don't think our confidentiality statute is a good statute at all. I've spoken publicly about that many times. And this is why the regulation by the marketplace is so important. Mediators get reputations, and questions go out on those listservs, both within law firms and bar associations, about who's a good mediator and who's not. And I think it's good that there be a free flow of information about mediators. The regulation of the marketplace is the most unforgiving regulation of all.
It is indeed. And with that, could we move to the next slide? We want to go through some of the ethical foundations of the mediator's role. You're the mediator, Jeff. Tell us about model role.
So, Joel, I think this applies most specifically in the pro se situation. People are representing themselves, explaining the role differences to people. In commercial cases, in the world where I make a living, people come with lawyers and people come understanding that their lawyer's a lawyer, and the mediator, while he or she may be a lawyer, is not their lawyer. And what we have to say should be viewed, recalling that we work for the other side as much as we work for you. And the most reliable advice that clients get in a mediation is the advice that comes from their own fiduciaries, their own lawyers, the people who owe them the duty of undivided loyalty, who've been living with the case for weeks or months or maybe years, and really understand the situation the best.
Next slide, please. We talked a moment ago about role confusion and the dangers of it. But here's a practical example. The party asks, what should I do? The mediator's role is to, it's your turn, Jeff.
Yes, there's a number of ways to deal with it, Joel. They all have in common that we should not be telling people what it's in their best interest to do. There are a lot of ways to deal with it. One is just to say, my job as the mediator is to help put you and your lawyer in the best position to decide for yourselves what is best for you to do. You should rely on your lawyer's advice. Your lawyer is the one with the duty of undivided loyalty. Sometimes I'll say to somebody, well, I'll tell you what I would do, but I'm not you. And I have my own psychological profile. I have my own financial situation. I have my own tolerance for risk. I have my own sense of other things going on in my life. So if you're interested in knowing what I would do, I'll tell you. But as terms of what you should do, that's something that you have to decide with your own lawyer based on the particulars of your own situation, financially, legally, psychologically, and whatever other dimensions come into play.
And with that, we have another question posted in the Q&A. I'd like to go ahead and read it now. Ralph asks us, if the demand or lack of a potential mediator is a factor in selecting a mediator, how can their demand or lack thereof be determined?
Well, that's just who's busy and who's not.
I think is the answer.
Yeah. Okay. So in preparing for a mediation, a lawyer mediator discovers there is a key legal issue neither side has recognized, which is potentially dispositive to one side or the other, dramatically impacts the value of the case. What would it be ethical for the mediator to do in terms of alerting the parties under 518? So I'll just tell you how I've operated in terms of neutrality for many years. Every time I go into a caucus, let's say Joel is the party with whom I am not caucusing at that time, but I'm going into a caucus with Joel's opposing counsel. Let's hypothetically call him Sean. So when I go in to talk to Sean, I imagine that Joel is sitting on my shoulder, like in the old Bugs Bunny cartoons, little angel and the devil sitting on the shoulder. And I imagine Joel is sitting on my shoulder and he's watching what I say to Sean in the caucus. And Joel has got an eye out to make sure that I don't say anything or disclose anything that would prejudice him inappropriately. And I think in this case, if there was some great case or great argument Sean had not yet discovered, and I go in to talk to Sean about it, I think Joel would be very upset if I were to say, Sean, there's this great case out there. I'm surprised you're not citing it. That's not neutral. That's not appropriate for a mediator to do. So if the parties have not discovered some fact or some aspect of the law, then they just haven't. And you also have to keep in mind that you as the mediator may think that you're correctly interpreting the facts or the law, and you may not be. So don't be so sure. I try not to be so sure of myself in saying, this lawyer has overlooked X, Y, or Z. Maybe the lawyer has not overlooked it. Maybe the lawyer has a perfectly good answer for it. But I don't think it's my job to tilt the pans of the scale in any way. Joel, where do we go next?
We go to the next slide here where we have an opportunity to discuss another foundational rule, Model Rule 8.4, which of course talks about prohibiting dishonesty, fraud, deceit, and misrepresentation. And in the context of 518, suggests that there's a higher expectation of honesty, lack of fraud, no deceit, no misrepresentation to be imposed upon neutrals. And
that's right.
The takeaway from this is that we as advocates get away with a certain amount of puffery and leeway in that regard, but the neutral does not.
That's right. And I think we've discussed that in some detail.
So let's move to the next slide, please, which is intended to discuss what amount to high-risk statements on the part of the neutral and how those high-risk statements are affected by 518.
Yeah, well, let's take the first one, Joel. This is the best offer you'll get. Maybe. And again, when the mediator comes in and says it's a form of hearsay and not reliable, I think that the question that a lawyer should reflexively ask when confronted with such a statement is, are you sure? Or how do you know? And I think that a lawyer has the right, indeed the obligation, to test the hypothesis for him or herself. So I've had many lawyers suggest, or if they say they want to test the hypothesis for themselves, I say, let's go down the hall. We'll have a meeting just of the lawyers, or if we're on Zoom, let's have a breakout room just of the lawyers. And you, Joel, can look Sean in the eye and say, listen, you say this is the most you're going to pay. My client wants more. You can try to call Sean's bluff. And that way, when you go back to your client and advise your client as to whether this is or isn't the best offer you'll get, it's based on your own hard work, your personal discharge and fulfillment of your duty of competent representation. You're not allowing the mediator to substitute independent judgment for yours. If the mediator comes in and says, this is the best offer you'll get, that's the mediator's independent judgment. But your client is entitled to your independent judgment. And as lawyer, you have to...
Sometimes as advocates, we need to test that.
Yes, you have to.
We recently did a mediation a month or two ago where, the situation kind of devolved to a meeting between the mediator, myself, and counsel. No parties were present. And counsel saying, well, this is what this case should resolve for. And my job in that particular instance was to say, as an advocate, I'm here to convince you that that's simply not the path to resolution in this case. If you insist on that, we're not resolving. It's not going to go away. This is what's doable, and this is how I'm going to try to persuade you that what's doable is what should be the result in this, or the resolution of this case. Unfortunately, in that particular situation, it worked. But again, at some point, it's for the lawyer as advocate to test those assumptions, not for the mediator to test the assumptions.
Well, that's right. Your client is entitled to your independent judgment, not the mediator's independent judgment, because you are the one with the fiduciary obligation of undivided loyalty.
Would you like to go through the second and third things, these high-risk statements, or shall we move on?
I think they're sufficiently similar.
Then let's move to the next slide, please. I'm mindful of the fact that we're about 10 minutes away from our nominal end of this presentation. There's a difference between legal information and legal advice. As an advocate,
yes, and
I get to provide legal advice.
And Joel, this dovetails with the discussion of best interest evaluations. And let's just jump right into mediators' proposals, because that's where a lot of the heat has been generated in the wake of 518. And, mediators, here's the crazy thing about mediators' proposals. Mediators disclaim that there's any best interest recommendation in a mediator's proposal. This is just the number that I think both sides would be willing to accept. I'm not evaluating the merits, et cetera, et cetera, et cetera. We've all heard mediators say that. This, in my judgment, is what we would call a legal fiction. Because what happens when the mediator's proposal is in the hands of the lawyer, and the lawyer takes that mediator's proposal to the client and tries to use that situation to get the client, if the lawyer thinks it's the right thing to do, to pay more or take less than the limit of the client's previous authority. That's when a mediator's proposal is used. when people have hit their limits, nobody's willing to make any further moves or compromises, and yet the aroma of settlement is kind of in the air, and maybe nobody wants to let it get away. So how do lawyers actually use mediators' proposals? They don't go to their clients and say, well, the mediator is disclaiming any evaluation, and the mediator is just thinking this is the number people would agree to. No, that's not what happens in real life. Lawyers go to their clients and say, Judge so-and-so or mediator X has made this mediator's proposal. I know it's more than you want to pay or less than you want to take, but this is where the mediator thinks the case should come out. The mediator has heard all the arguments. The mediator thinks this is in your best interest. So notwithstanding the disclaimers that mediators put in real life, lawyers use that very analysis to try to persuade clients to accept the mediator's proposal, to go farther than they ever thought that they would go in the negotiation. And that's why it's critical that the mediator's proposal reflect not the mediator's independent judgment, but the lawyer's independent judgment. And so that's why I suggest that mediators, to allow lawyers to fulfill their ethical obligations, engage in a two-step process. One, before a mediator makes a mediator's proposal, the mediator should make sure people consent to the concept of a mediator's proposal. Joel, you've been stuck at your position. The defense has been stuck at its position for 2 hours. People are still here. I think they still want to settle the case. What about a mediator's proposal? Do you think it's time? And assuming that both sides say yes, well, first of all, if somebody says, no, it's not time for a mediator's proposal, fine. You explore, well, why or why not? What do you suggest we do instead? And we figure out collaboratively a way to move forward in the negotiation. Let's say both sides say it's a mediator's proposal. Lawyers should then have the opportunity to have that prospective mediator's proposal vetted with them. So let's say, just hypothetically, Joel, that the plaintiff is stalled out at 60 on a scale of 1 to 100, and the defense has stalled out at 50. Mediator says, oh gosh, is it time for mediator's proposal? Yes. Mediator comes to you, Joel, and says, you're on the plaintiff's side, says, 50, 60, well, what about 55? And I think you have every right to say, no, don't just pop a number on me, Jeff. I want to make sure that it's the most within that range of 50 to 60. I want to satisfy myself that this is the most money that is obtainable for my client. Because your client is going to ask you an acid test question. The client is going to ask you, is this the best deal we can get? Joel, you're asking me to take less than I ever dreamt I would consider taking in the settlement of this plaintiff's case. In order for me to live with myself, not have second thoughts and regrets, I need to know, is this the best deal we can get? It's the question that plaintiffs are always thinking and are almost always asking. In order to be able to satisfy the client that yes, you, based on your independent judgment, have determined that it is the best, you cannot just accept the mediator's judgment as to what that number ought to be. The mediator should be giving you a right, Joel, to say 55 is just not enough. If you expect my client to come down from 60, well, maybe he'll come to 59. And then we mediate what the mediator's proposal is going to be. That way, when we finally have a number that both the plaintiff's counsel and the defense counsel are willing to recommend to their client, based on the lawyer's own hard work as to what is the best possible number they could get in that negotiation of what the mediator's proposal number will be, then the mediator validates that number and formalizes that number in the form of a mediator's proposal. Then, when your client asks you, is this the best we can get? You can honestly say, yes, the mediator initially suggested that we take less, but I pushed back. And either I was successful or not, but I pushed back, I fought for more, and this is the best deal that you can get today. That way, your client has the benefit of your independent judgment, not the mediator's independent judgment. And that is the advice, and that's what a lawyer needs to be able to do to fulfill their 1.1 and 2.1 ethical obligations. And that's what mediators need to do in order to keep mediation as a safe place where lawyers can come and not be painted into a corner where they're just not able to fulfill their ethical obligations to their clients.
Jeff, this puts in mind something that happened to me many, many years ago, back before there was a lot of private mediation. But we were in an era in which there was court-ordered mediation. It was expected. And I had an occasion to be in one of these situations. And I had a client who I thought I was representing the defendant at that time, and I had a client who I thought had a really righteous defense to the case. And the mediator was doing what mediators do. They were trying to find a resolution. And I kept going back to saying, no. Thank you, Mr. Mediator. I appreciate your efforts. We appreciate the opportunity. But sometimes, in the words of the aged Judge Murphy, courts are for courting. I think I've got a righteous defense here. I'm not going to do your mediation. I'm not going to agree to any sort of compromise because I can win this case. I realize it's a little weird to say this in the context of a conversation about mediation and mediation ethics, but every once in a while you have to say, no, this is not the best possible result. Your mediator's proposal is not necessarily in my client's best interest. This is what my client can and will do. And if you think that if you want to suggest a mediator's proposal that's different from that, what I think in the exercise of my independent judgment and my client's judgment is what he's willing to do, then we're simply not going to resolve this day. And in the final analysis, that's kind of the way mediation works. Sometimes you get a resolution and sometimes you don't. But if every
once in a while, Joel, you come across somebody who's just too greedy or too stingy, and it's not settlement for the sake of settlement. It's settlement wherever reasonably possible. And the fact of whether a case settles or not, we like cases to settle. Don't get me wrong. Mediators love it when cases settle. But there are some times where it's just not the time. And again, if the clients are making clear, strong decisions in a calm, informed environment, and they want to go forward with a clear conscience, no regrets, no doubts, no second guessing, well, I don't think that's an unsuccessful mediation. I think the client has made the best decision for them under the circumstances.
And as we all know, if a case doesn't resolve on the initial day of the mediation, good mediators such as yourself keep trying. And the case may not resolve the first day you mediate the case, but it may resolve thanks to the work that the seeds that have been planted by the mediator and planted by counsel in that mediation later on. And that's okay too.
Yeah, and we follow up like a dog with a bone until we're told, just, don't bug me anymore. We follow up and we try to keep people's eyes focused on that settlement prize because most people, if given a choice, most people would like to put contentious situations behind them if there is a reasonable way to do so they can get on with their lives, their careers, their businesses, their families, and everything else that's happening in their worlds. Joel, we could go on for a long time about this, but I see the clock on the wall tells us our hour is about up.
Our hour is about up. We do have a number of slides that we haven't gotten to yet. The slides are available to the audience for their review. If anybody has any questions about the slides, either the ones we've seen now or the ones that you've not yet seen but have available to you, you're always welcome to reach out to either Jeff or I offline. We'll be happy to discuss them with you.
Yes.
And
And
with
Joel, I would just want to sum up by saying we as mediators are not here to supplant you as lawyers. We're here to support you. If it's with evaluation, if it's with support in helping clients get unrealistic expectations back into line with reality, we're here to support you. And we must also constantly respect your role and the difference between your role as ours, or the difference between your role and ours. So we're here to support, we're not here to supplant. And if everybody keeps in mind what their roles are, I think mediation will continue and grow as a very valuable part of the dispute resolution process and invaluable to excellent lawyers in the world of litigation and elsewhere in the practice of law.
I agree completely with that. And with that, I'd like to thank Jeff, our introduction from Catherine and the Beverly Hills Bar Association for the opportunity to be here today. And we don't have any further questions posted in the Q&A. So with that, I suggest that we're done for the day.
Thank you.
This concludes today's presentation. Thank you so much, Jeff and Joel, for an excellent presentation today. And thank you so much to our audience. Have a great day, everybody.